Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest today is Eric C. Chaffee, Professor of Law at the University of Toledo College of Law. And he's going to be discussing his scholarship on the collaborative theory of corporations in relation to both corporate social responsibility and charitable organizations. So welcome, Eric.
Thanks, Brian. Glad to be here.
Yeah, so as you know, I'm a big fan of these papers, which I read in the past and just had an opportunity to reread this morning. And I'm really looking forward to talking to you about them. But before we launch into kind of the difficult questions about collaborative theory and corporate responsibility and charity law, I was hoping maybe you could give the listeners a little bit of a background in the history and different theories of the corporation, because I think that'll be really helpful for them in understanding your argument and why it's so interesting.
Great. Happy to do it. So this piece, the further you get along as a scholar, I think the more you question the foundations of what you're doing. Meaning that, as a young scholar, often what you're trying to produce is a very nuanced piece about something that's hot and cutting edge. And sometimes you don't really get into the basic questions that you really need to explore to be a very good scholar in a particular field. So this particular field, or this particular project, what I'm trying to do is to explore the question of what is a corporation. And that sounds like a really basic, easy question. I mean, corporations have been around for centuries. There are lots out there. They're incredibly important in our lives. But at the same time, there's been a lot of debate over what they happen to be. We know that corporations have deep roots, which I trace back to ancient Rome, because the word corporation comes from the word corpus, and there were various entities that looked like corporations during that time period. And, largely what they served was social purposes, burial societies, social clubs, homes for the poor, the aged, that sort of thing, and even the Roman state. And throughout time, that notion of the corporation was developed. The Roman Catholic Church, for example, during the Middle Ages, they developed the notion of the corporate personhood, this notion that the corporation is a fictitious person. From there, we see those types of ideas imported to England, and at that point, there was this idea that corporations could be used for societal development, and at the same time that they might have a business tension. So we see things like companies being chartered for the exploration of land. Mm-hmm. Ultimately, notions of the corporate form end up being imported to the colonies. And during that time period, to have a corporation, basically what you had to do was to petition the colonial legislature, which is sort of surprising because we think of corporations as being relatively easy to form today. But at the same time, what they were during that period, or during that time period, better put, was basically these entities that you had to go and petition the legislature. They were bespoke. And often they were used for social purposes, mm-hmm. Meaning that ultimately you would.
Eric, when you say social purposes, what do you mean by that? What are you distinguishing it from?
Well, it'd be something that almost looks like an administrative agency. Mm-hmm. Somebody or a colonial legislature would decide that they needed a road, or they needed a canal, or they needed a bridge maintained, or they needed a bank. And as a result of that, they would partner basically with private individuals to make that particular thing come into being.
Right. So different. So different from what we think of as kind of a typical business corporation today, like some sort of like maybe quasi nonprofit or like public-private partnership-y type stuff.
Yeah, very much. The benefit corporations that people now talk about being really cutting edge, in fact, look kind of like what exactly the state was doing during those periods, meaning that the state saw that in addition to what it was capable of doing, that there were other social needs, so they allowed for the chartering of these business entities, often granting monopoly, often partnering with people who were interested in profit, and these corporations would come into being.
Mm.
So from there, where we see it progress, notions of private property ownership and industrialization and that sort of thing come into being and become ingrained in our culture. So during the late 1700s, early 1800s, we see the first general incorporation statutes. Ultimately, if somebody wanted a corporation, they no longer had to go to the legislature for purposes of creating that corporation. They just simply could file documents with the state. And really at that point, it's where we first see the divide between nonprofit and for-profit corporations for the first time.
Okay.
So, there we see basically the modern corporation come into being, and that ends up being bolstered by, the Dodge v. Ford case that we saw during the 19-teens, where the Michigan Supreme Court essentially said that corporations have to primarily be focused on seeking profit, which some scholars have transformed into this notion that basically corporations have to be these wealth-maximizing beasts that seek profit relentlessly, although obviously there are scholars that take issue with that.
Mm-hmm.
So playing against that backdrop are scholars who are essentially trying to struggle with the issue of what exactly is a corporation. And there are really three prevailing theories that came into being that have persisted throughout the existence of corporations, although during various time periods, each one really has been the dominant theory. Mm-hmm. Meaning that initially there was this idea that corporations were these artificial entities or these concessions that were granted by the state. Mm-hmm. And as a result of that, they essentially owed their life to the state, and the state held a whole lot of power over how they could be regulated.
Okay.
They did have separate entity status, but at the same time, they really were given life. They were sculpted into existence by the state. And that was the initial notion of the corporation. And it dovetails really nicely with that period of time where corporations were bespoke entities that had to be chartered first by the crown, then the parliament, then the colonial legislature, and then finally the state legislature. Mm-hmm. Well, as the general incorporation statutes came into being, there really was this question of whether or not the artificial entity theory or concession theory, as it's sometimes termed, was an adequate description of the corporation. And as a result of that, scholars in the United States began looking to the continent, began looking to European scholars for purposes of essentially trying to figure out what a corporation is. And they looked to the work of Otto von Guercke. He had suggested that any time that you have a group of people, that they take on a collective identity. And he extended that into corporate law with the notion that corporations essentially are natural entities or real entities that essentially reflect the collective personalities of the individuals owning, organizing, and operating. In terms of thinking about that theory, definitely the corporation is a separate entity, once again, similar to concession theory, popular throughout much of the 1900s into probably the late 1980s. Eventually lost steam because there was a marriage of corporate law scholarship in the United States to economics, meaning the 1980s. Essentially, you have the Chicago School and a bunch of scholars saying, it's exciting to essentially marry economics to corporate law because it allows for all sorts of sophisticated analysis. And as a result of that, despite the fact the real entity theory or natural entity theory may adequately describe aspects of the corporation, it doesn't really allow for that analysis. Mm-hmm. So what happened is that economic scholars and legal scholars started looking to the work of Ronald Coase, he had suggested that what the corporation really is a nexus of contracts, or, as it's sometimes termed, an aggregate theory of the corporation, where essentially it's just the sum of its parts, and that is what adds up to the corporation. Usually with proponents of the nexus contract theory of aggregate theory, they don't even believe that the corporation should really have a separate entity status. They think that, really everything should be derivative from the people composing the corporation.
Okay.
Certainly all the theories have things to like about them. They all basically emphasize some attribute of the corporation. The artificial entity theory basically emphasizing the role of the state, the real entity theory emphasizing the corporation itself, and the nexus of contract theory basically emphasizing the individual players within the corporation, the people organizing, owning, and operating it, but really not a thick and robust definition of what the corporation happens to be.
Okay.
For that reason, early 1900s, you have John Dewey, and you've had people more recently, such as Bill Braden, who's a scholar at the University of Pennsylvania, which you of course know, saying that essentially what we need to do is to embrace the indeterminacy of the corporation, meaning this notion that all of the theories have something to like about them, but despite the fact that they're contradictory, we just simply ought to wrap our arms around all of them, sort of throw our hands up in the air after that. And even though there's inconsistency, we just ought to embrace all of these theories to get a more robust, better definition of the corporate form.
Huh.
And that's really where my scholarship begins.
Okay, so it sounds like you described three different theories here, right? So it's the concession theory, which says corporations are just a creation of the state. Entity theory says that corporations are kind of brought into existence by people engaging in corporate activity together. And then this aggregate theory saying that the corporation is just the relationships between the people who operate the corporation. Would you describe these as normative theories, descriptive theories, some combination of the two? Like when we call them theories, what are we talking about?
They're designed to be both, meaning that ultimately they're designed to be descriptive in the sense that they are meant to provide a definition of what a corporation is, but at the same time you're supposed to be able to build from them to make determinations about how corporations ought to be regulated.
Okay.
And there definitely are a couple of different ways that you can go in thinking about how corporations ought to be regulated. One is to start off by thinking about essentially what is a corporation and working from there. The other is, and there are people who actively advocate for this, and I think this is partially what John Dewey was trying to get at, this notion that, okay, corporations just exist, so, figure out how to we should just figure out what the right way to regulate them is without figuring out essentially what they are. And my scholarship at least sort of strikes the middle ground between that. Ultimately, I do think that we have to have certain sorts of positive law in regard to regulating corporations to make sure that they are behaving in ways that they ought to be. But at the same time, if we can understand what corporations are in the first place, we know where we're starting. And in addition, if we can figure out what that definition means, it allows us to predict what corporations should be doing in the event that the government hasn't stepped in, hasn't decided to regulate yet.
Yeah. So my reading of both of these papers was that you sort of appreciated how Dewey recognized the sort of merits and demerits of each one of these three prevailing theories, and then kind of took this pragmatic position saying that, well, we'll sort of, they all have something good about them. We'll take them as a whole and see how we can produce the best outcomes. But you seem to be arguing that that's just not enough, that that's missing something as well, which is why you proposed this new collaborative theory. Am I getting that right?
Yeah, that's exactly right. I mean, John Dewey very clearly was a man of his times, a scholar of his times. At the point where he was writing, sort of made sense. Okay, we have these various theories. They all seem to describe some aspect of the corporation. Let's put our arms around all of them and just figure out what the best thing to do is in the individual situation. That being said, I mean, when we have cases like Citizens United, Hobby Lobby, Masterpiece Cake Shop, figuring out what a corporation is in the times that we actually reside in now has become much more important than what it was in Dewey's day.
Yeah.
The other thing is I just think that a better definition is possible. If we look at this as a process of figuring out what a corporation happens to be, answering that deep metaphysical question, really none of the prevailing theories do that. They all talk about how the corporation exists without talking about why the corporation exists.
Mm-hmm.
And what I mean by that is that, if we take a bridge, for example, for example, we could describe a bridge as basically something created by the government. I mean, that would be the artificial entity theory of a bridge. And not a very good definition. Or we could describe a bridge as just something that exists. And that wouldn't be a terrifically good definition of a bridge either, but that would be the natural entity or real entity approach. And then finally, we could talk about a bridge as just a sum of its aggregate parts arranged in a certain ordering. And that has some descriptive appeal to it. I mean, it does give us a sense of what the structure looks like and how you create a bridge. But, none of those things really define what a bridge happens to be. And until you come up with a definition like a structure designed to allow individuals and objects to be transported from one place to another, or basically to span over some sort of obstacle for purposes of transporting something from one place to another, you don't really get a robust definition. And the reason why that's a robust definition is it talks about how the bridge exists as a structure, but it also talks about why, meaning what the purpose of the bridge is. Mm-hmm. And in terms of my work, I like all of the prevailing theories, or I like aspects of them, but I just don't think that they've fully captured what a corporation happens to be.
Uh-huh. Uh-huh. So in your paper, again, you propose this collaborative theory and then show, I think, in some really interesting ways, both how it helps understand the concept of corporate social responsibility better. And then you also, I think, make some really interesting observations about how thinking about corporations under the collaborative theory helps us resolve in a more satisfying way some of these kind of normative problems around corporate regulation you've talked about, like, corporate First Amendment speech and, the choice about who to sell to and all this kind of stuff, which I want to get to in a second. But I think first I really want to know, like, how does the collaborative theory work? Like, what does it do different? What is the collaborative theory?
So in terms of thinking about collaboration theory, essentially what it posits is that corporations are essentially collaborations among state governments and the individuals organizing, owning, and operating the corporation. And, I've been struggling with, and I've still been thinking through the question of how widely that collaboration ought to extend. Should I extend it, for example, to creditors, customers, that sort of thing? There are people who claim that the aggregate theory, for example, ought to be extended that broadly. Mm-hmm. So I haven't gotten to that piece quite yet. But as a starting point, the notion is that it's a collaboration between state governments and the individuals organizing, owning, and operating the corporation. And then in addition to that, now that we understand how the corporation exists, I add a component of why the corporation exists. And for for-profit entities, what I argue is essentially that it's for purposes of economic development. Mm-hmm. And probably the thing that pops out to you at that point is, well, the state's goal is going to be very different than the individual goal. For the state, it's going to be basically societal economic development, societal financial gain. For the individuals organizing, owning, and operating the corporation, it's going to be for personal economic development, personal economic gain. I don't think that stops or is fatal to collaboration theories in any regard. And the reason for that is there's all sorts of collaborations out there that essentially people have different goals. For example, musical composition, the person who's producing the song, recording the song is going to have very different goals than the artist versus the backup singers. It doesn't stop it from being a collaboration. And in terms of thinking about that, one of the other things that may be popping out as well is it's really any different than in any of the other corporate law theories. First off, I do think it's a thicker explanation of what a corporation is. Second, in addition to that, I think that it's better branded. It better describes what a corporation happens to be, and it does take issue with some of the prevailing theories. Most notably, for example, the nexus of contract theory doesn't really explain why you end up with separate entity status for the corporation.
Right.
Collaboration theory, I build on that work of Otto von Guericke, this notion of collective identity and the notion of collaboration, two heads being better than one, two heads being more than one, to actually answer the question of why you end up with separate entity status.
Yeah, I mean, it seems like one of the things that's really unique and interesting about it is that it takes the normativity of corporation theory a lot more seriously than some of the other theories, in a sense that it says, in thinking about the definition of a corporation, we have to think about the purpose of the corporation itself.
Yeah, I mean, I was pleasantly surprised how nicely this particular theory answers a whole lot of questions that are really, really difficult in the corporate law theory, or in terms of corporate law theory, that are hard to answer with any of those other prevailing theories.
Mm-hmm.
And what I mean by that is, in addition to answering really difficult questions about corporate social responsibility, it helps to answer the questions about how corporations ought to be governed, how shareholder democracy ought to work,
Mm-hmm.
The long-termism versus short-termism debate, corporate social responsibility, tax avoidance, political speech, religious freedom, all of these really difficult issues that we've been struggling with as corporate law scholars for centuries.
Yeah. Well, as a little bit of a tangent, one thing that struck me when I was reading both papers was that in some ways your collaboration theory reminds me of like a version of stakeholder theory, but there's something different about it as well. Am I reading it correctly?
I definitely think that stakeholder theory and governance theories are at play here, but, I draw a line, and not all corporate law scholars do this, but I think that they ought to, between essentialist theories and then governance theories. The reason for that is that essentialist theories are really getting at the metaphysical question of how exactly corporations exist, whereas when it comes to governance theories, they're asking more of a political question of how corporations ought to be governed. And I do think that this particular theory leads to some conclusions about governance. We have all of these different theories of governance in terms of, should it be basically a director-focused theory or a director-focused system of governance? Should it be a shareholder system of governance? Should it be team production? And actually, that team production theory, this notion that, it's all these people coming together in a collaborative way, basically to run the corporation, I think actually dovetails pretty nicely with collaboration theory. Because the notion is that you have these different parties working together and arranged in such a way where it really is a team working towards a common goal.
Right. Well, so in your most recent paper, you focus specifically on how the collaboration theory helps us better understand corporate social responsibility, and specifically the implementation of corporate social responsibility from the perspective of the directors of specifically a for-profit corporation. I was wondering if maybe you could kind of lay that out a little bit.
So I've always been troubled, and this happens quite regularly. You'll attend an event and you'll hear somebody speak who is a director, officer, high-ranking person, respected part of a corporation, and they'll say, "Well, we ought to take an approach that basically involves corporate social responsibility because it's the right thing to do." And, I'll sit there and I'll puzzle what exactly they mean by that. And I think there are a couple of different ways or a couple of different things that they might mean by what they're saying. First off, this notion is that it's better for the bottom line, meaning that, ultimately we have this obligation to do corporate social responsibility because society wants it. And they're going to treat corporations better if they actually engage in corporate social responsibility. It's going to protect the entity better. It's going to make sure that customers continue to come back because they know that they're dealing with a corporate firm that engages in corporate social responsibility and that sort of thing. And I think that's fully backed up in terms of how people conceive of corporate law today. This notion that corporations are supposed to be primarily focused on profit. And that goes back to that seminal case of Dodge v. Ford, where the Michigan Supreme Court stated that, that's completely and totally what corporations ought to do. Mm-hmm. Well, the problem is that there are three other cases that are lurking in the background. First off, the circumstance where basically it's cost neutral. Meaning that, assuming that you're able to do the cost-benefit analysis, that the question of whether or not to do corporate social responsibility doesn't have a clear cost-benefit, and it doesn't have any sort of impact on the bottom line, where essentially it's zero if you do the socially responsible activity. Second circumstance would be a circumstance where the cost-benefit analysis is unclear. I mean, it's really, really hard to predict the future. And the question is, why exactly should you tip in favor of doing the socially responsible activity if you happen to be a corporation? And the third in circumstances where something's legally permissible, but at the same time, in fact, it's socially irresponsible. So in terms of thinking about that, the first two cases, my theory answers why exactly you should do the socially responsible thing. The notion being essentially that when in doubt, err on the side of doing the socially responsible thing because you're in a collaboration with the state. We have that famous case out there, Salmon v. Meinhardt, where Judge Cardozo said that basically individuals who were collaborating within business entities owe each other a punctilio of an anonymous sense of it. Mm-hmm. And in addition to that, I mean, there is a contractual basis to this theory. That there's a duty of good faith that underlies all contractual relationships, meaning that people who essentially enter into contracts with each other ought to be behaving well to each other. And as a result of that, there's two circumstances where if you really pressed a corporate manager as to why exactly the corporate social responsibility or corporate social responsible thing to do was the right thing to do, most of them will resort to intuitionism and just say, well, it's the right thing to do. My theory actually answers the question that why in the circumstance where the cost-benefit analysis is cost neutral or in the circumstance where the cost-benefit analysis is unclear, you ought to do the pro-social thing. Mm-hmm. Basically, it's individuals collaborating with the state. That, of course, leaves that other category, circumstances where something is legal to do, but at the same time, and at the same time, better put, essentially is socially irresponsible. I do think that corporations have an obligation to do that as long as the particular activity is legal. Mm-hmm. And that's disturbing to most people because it means that there's going to be circumstances where corporations do bad things. For example, prior to a lot of environmental regulation, it meant that corporations dump stuff into rivers. Mm-hmm. That being said, I have a couple of responses to that. First off, because we know that life is so unpredictable and that doing cost-benefit analyses, we can give clear and clean hypotheticals, but that's just simply not the way that life works. That's only going to be the rarest of rare situations where you find something that's legal to do, where it clearly benefits the corporation, but it's still it's socially irresponsible. And in addition to that, it does show what the role of positive law is, meaning that, if you are a legislature, that's what you ought to be seeking out for legislation. You ought to be trying to alter the cost-benefit analysis. And the environmental law example is actually a pretty good one. Ultimately, in terms of environmental regulation, we came to realize that corporations were going to dump toxic things, and as a result of that, as a society, we came together and passed environmental laws to alter the cost-benefit analysis. And as we moved essentially what was in that fourth category into a clear case where it was better for the corporation to do the right thing.
Right. Right. Well, in a way, it's almost like what you're saying is, the state is a collaborator too, and its job in this collaboration is to save the corporation from making bad decisions, when it would otherwise be forced to.
Yeah, that's a great point. I mean, definitely, my view is that, all of the parties involved here, the individuals owning, organizing, and operating the corporation or collaborators, but also the state. But definitely the state does have a substantial role. And in terms of thinking about that role, it helps to explain why, in certain instances, we can regulate corporations in ways that we can't regulate people. For example, with political speech. That jumps to mind, or potentially in regard to the religious freedoms of other individuals who happen to be involved with the corporation as their owners, organizers, or operators. It actually, provides a relatively neat way of thinking about the Masterpiece Cake Shop, a case from last term regarding how exactly corporate rights should intersect with religious rights.
Interesting. Well, I want to get to that in 1 second because I actually really like that part of your argument as well. But there was one other thing that I noticed that I also really liked about your corporate social responsibility argument is that in a way it provided one of the better descriptions of the seeming tension between Dodge v. Ford and the business judgment rule, right? Because everyone knows, like Dodge v. Ford says you have to do the profit maximizing thing. But in practice, the business judgment rule says that it's almost impossible to stop the corporate directors from doing whatever it is that they think the right thing to do is. And in a way, I felt like your description of how the collaborative theory works in this context tracks so nicely under that practical reality.
Yeah, I mean, definitely in terms of thinking about the business judgment rule, it does give very, very wide discretion, as long as you can articulate any sort of business judgment. I mean, honestly, I think that if Henry Ford, rather than claiming that he was going to run Ford Motor Company to benefit the people, had said that what he was doing was trying to drive the Dodges out of business or preventing them from starting their car business, that the court would have said, fine, that's a business purpose. We're perfectly fine with that, despite the fact that, it's anti-competitive.
Yeah.
But, ultimately the business judgment rule provides a wide latitude, but collaboration theory does provide a check on that, meaning that, it gives certain instances where there have to be outer limits to the business judgment rule, where there have to be circumstances where, a business explanation simply won't be enough for certain sorts of behavior. Right. And it gets into some of those really, really tough issues when it comes to thinking about individual rights and corporate political rights. It gives some explanation as to what exactly courts ought to do in those particular circumstances, and why exactly, corporations, because they are creatures that have been created by the state and collaborated, and their collaborations with the state, why exactly, certain sorts of regulations of corporations are permissible.
Right. So that was something I thought was really interesting about the way you articulated the role of the purpose of the corporation in collaboration theory. in relation to explaining why it is that corporations can and should be regulated differently from the way that individuals are regulated with respect to particular kinds of social behaviors?
Yeah, I mean, I was pleasantly surprised how well this mapped on to how individuals generally, I'm not talking about people with legal training, feel that corporations ought to behave, both in terms of corporate social responsibility, but also in lots of other contexts. There really is a thickness to this theory that I think that the other theories lack. And it helps to explain some really hard problems of our day. Political speech, for example, with the government speech doctrine, which essentially says that if speech is being attributed to the government, that ultimately the government has a say in what that speech happens to be, helps to explain why the money that's being dumped into our political process by corporations and by business entities, why there might be grounds to regulate it. And hopefully at some point courts will actually pick up on this theory and do some of the work that they need to in terms of making sure that corporations really are serving the function that they're designed to achieve, which is economic development, both for individuals and our society as a whole.
Right. And that's what I really like. I mean, it's like, it struck me that it's like, as soon as you adopt, or as soon as you make a little bit more robust the idea that a corporation has a social purpose, even a business corporation has a social purpose other than just profit maximization, all of a sudden it becomes much easier to say, well, and that purpose may not include all of the kinds of purposes that might be legitimate for individuals. In other words, a business corporation may not have the purpose of engaging in extensive lobbying with respect to contentious social issues, for example.
Yeah, and it is interesting. I haven't been called a communist yet in any of my presentations, and I don't get there. And I think I have a pretty good response to that, basically the deal that's being struck with the state is that the individual should be going out and seeking profit and doing it relatively aggressively. But, it helps to set the outer bounds of that. And, there have been scholars out there, Elizabeth Pullman, who's at Loyola LA, and Jordan Berry, who is a scholar at University of San Diego, have talked about questions in terms of corporations who've been aggressively engaged in law breaking for purposes of essentially advancing, their own business models. I think that this particular theory gives some indication that, corporate law breaking really should not be a thing that corporations engage in, because there are metes and bounds at the outer limit of what exactly corporations should be allowed to do. And the government has a role in setting what those metes and bounds are as collaborators in the process.
Okay. Yeah, I love it. And okay, so for the last few minutes of our conversation, which I really wish we could keep talking for longer, I wanted to get at another aspect of your scholarship, which I also really like, as a fellow charity law nonprofit scholar, in that one of the things I really like about your collaboration theory is it breaks down, this sort of typical hard line distinction between business corporations and charitable corporations, right? I mean, typically in law school, in legal scholarship, we tend to treat them as totally distinct categories, different animals entirely, right? Business corporations are one thing, charities are another. But once you start talking about the purpose of a business corporation in a more robust way, all of a sudden a lot of the governance questions and a lot of the kind of deep metaphysical, philosophical, normative questions start to look like differences of kind, not differences of type. And I thought that was really interesting and sort of an indication to me of the potential utility and descriptive power of the theory that you're proposing. Yeah,
I mean, this particular project, I had done some research, and had started looking around to find out if there were theories of nonprofit corporations. And I found that there wasn't really anybody who was talking about that. So, ultimately this project really came from that particular origin. And then as I worked on it, I realized that it extended so well to for-profit entities. The notion is that, if you're thinking about collaboration theory, it works well for for-profit corporations, but it probably even works better for nonprofit corporations.
Mm-hmm.
And the reason I say that is, when it comes to nonprofit corporations, in addition to having the people who are organizing and operating the corporation and the state, which breathes life into the nonprofit corporate form and gives it limited liability, you also have the federal government involved in that particular case, which is giving it tax-exempt status, assuming that it meets the criteria of 503C or one of the other provisions found in that area of the tax code.
Mm-hmm.
And ultimately, when it comes to nonprofits, I think that rather than economic development, you're really looking at social development or improving social well-being. There's a lot of commonalities there in terms of thinking about for-profit entities, in terms of how nonprofits and for-profits, ought to be managed in a similar sort of way, and thought about as being closer to each other than they are now. And if you look at the history of corporations, which there are a lot of people out there who haven't thought deeply about the history of corporations,
Mm-hmm.
that completely and totally makes sense because historically, until the late 1700s, early 1800s, there was no difference between nonprofits and for-profits.
Yeah, it's weird. Like everything old is new again, really. It's like
Yeah.
cycling back to an earlier way of thinking. And in a weird way, it struck me that, taken to its logical conclusion, in a sense, it seems to me like you could even conceptualize business corporations as a subset of charitable corporations, insofar as, charitable corporations have a broad range of different social purposes that they're created in order to pursue. And business corporations, in theory anyway, could be conceptualized as just corporations that have been created with the social purpose of maximizing economic welfare, right? Which is also a social good. It's just a very limited social good.
Yeah, that's a fantastic point. I think that's exactly right. I'm going to have to steal that.
Be my guest. Well, I'm glad I was able to offer something.
I'll cite it. Don't worry.
Well, I'm glad I was able to offer something to my guest. Eric, this has been a fantastic conversation. You know how much I've enjoyed reading these papers, and I really look forward to hopefully your forthcoming book on the subject.
Thank you. I really enjoyed this series, and I'm pleased to be a part of it.
Awesome. Well, I will talk to you soon.